Community land trusts grew out of the civil rights movement in the U.S. The first community land trust was established 50 years ago, led by Slater King, cousin of Dr. Martin Luther King Jr. Douglas Community Land Trust builds on this legacy, the spirit of Frederick Douglass, and the work of more than 250 community land trusts in different regions throughout the country. Racial and economic justice center our mission. Douglas Community Land Trust is a membership organization. We invite you to join.
So welcome everyone. Thank you for joining Douglas Community Land Trust or Douglas CLT Housing Search Know Your Rights webinar. If you're wondering if this webinar is for you or will it help you, or even if it's worth watching to the end, the answer is yes, yes, and doubly yes. You will be shocked how much you'll learn and how this info can be beneficial to you or someone you know, whether now or later. It's always good to know your rights. My name is Dr. Dinah Carter, and I'm the Director of Engagement and Communications at Douglas CLT. And accompanying me is my coworker and lawyer, Adam Malone, Director of Stewardship. Say hi, Adam. So Douglas CLT is a membership-driven nonprofit, racial and economic justice center our mission. Our aim is to prevent displacement and help individuals and the community build assets today and in the future through community ownership of land and collective stewardship. We invite you to learn more and join today by visiting our website, douglasclt.org. So before we get started, just a few things to note. If you have any questions during the presentation, please type them into the chat box in your control panel. I'll bring them up during the presentation, and we'll also have time for questions at the end. We encourage questions. We love questions, and there is no dumb questions. So don't be shy, ask away. That's what we're here for. So I just want to take the time to just say a big thanks to all our community partners. So thank you everyone on the panel. And today's presentation is presented by Susan from Equal Rights Center, and joining Susan to answer questions are experts Chris from the Office of Tenant Advocate, Susan from the Housing Counseling Services, Robert from Casa, Samantha from Neighborhood Legal Services Program, and Laura with colleagues, language interpreters from Your Next Solution. So without further ado, we'll turn the time over to Susan, our presenter and expert at ERC.
Great, thank you. My name is Susie. I am the Fair Housing Rights Program Manager at the Equal Rights Center, and I'm really excited to be here today. Thank you all for joining us. And today we're going to be talking about fair housing. For the other panelists, could you just nod quickly if you can see the PowerPoint? I want to make sure we're good to go. Great, thank you for the feedback. So we're going to be talking about fair housing today. And during the presentation, as Dr. Carter said, we do welcome questions. You're welcome to put them in the chat box. And then I will try to answer them during the presentation, or we will answer them afterwards. And my video decided to blur out, so give me a second. I'm just going to restart that before we go. Great. Okay. So by the end of this, I would also like to, actually before we start, I do want to say that while I will not be talking about the eviction moratorium, that's not my area of expertise. We do have other people on the call who are more familiar with the eviction moratorium and can answer questions about state EC and kind of what comes next now that evictions can restart in DC. So if you have those questions, please also feel free to put them in the chat, and we will make sure to answer them during this conversation from some of our other panelists, who I appreciate being here today. So by the end of this training, our goals are to be able to answer the following questions. First, we want to be able to answer what is housing discrimination. Then we also are going to be looking at what are signs that you may have experienced housing discrimination during your home search, so that as you're looking for a home, you're best able to identify things that might be discrimination. And then third, if you do encounter discrimination, then who can you report possible housing discrimination to? So those are our main questions for today. And just before we get started, I do want to provide a brief introduction about the Equal Rights Center. So the Equal Rights Center is a civil rights organization. We are based in Washington, D.C., and we seek to identify and eliminate unlawful and unfair discrimination in housing, employment, and public accommodations in our home community of DC, as well as nationwide. In particular, I work in our housing program, so we assist folks who are experiencing discrimination in housing, and we provide direct services to individuals who think that they've experienced discrimination in housing in Washington, DC, and the state of Maryland, and in Northern Virginia. So I'll be talking a bit later about our services, but please know that if you have experienced possible discrimination in housing, you can contact us. So one of the main things our agency does is civil rights testing. And civil rights testing involves trained testers who go to various housing providers to see if and how discrimination may be occurring. So I'm going to give a quick example via video where we have a white man and a Black man serving as testers. The white man goes into the property and says he's looking for a 1-bedroom unit and asks if any are available. The agent tells them they have 1 bedrooms available and to get his application in soon. A bit later, the Black tester comes in and says that he's also looking for a 1-bedroom unit and asks if any are available. In this case, the agent says, sorry, we don't have any vacant 1 bedrooms available right now, which is completely possible. And Washington, D.C. properties can go very quickly. They can constantly filling up, but sometimes the information that people are given during their housing search isn't actually true. And so testing can help us better figure out what exactly is going on. So for example, we had a client who contacted us and she has a voucher. And after she disclosed her voucher, the agent said that was fine, they take vouchers, but he made a weird facial expression and his whole demeanor changed. And then later when she was trying to get an application for the unit, he said that there was no point in giving her one because they already had a really strong application in, which is possible, right? Maybe they knew they were going to accept the person and they didn't want her to waste her application fee. But in this case, she contacted us and reported that she thought that they may not have wanted to take vouchers, which is illegal in DC to refuse to take housing vouchers. And so when we did testing, we had someone pose as having a voucher and someone as not having a voucher. And during testing, they told the person with the voucher that the unit was off the market, similar to what they told our client. And when the person without the voucher contacted them on the same day, the unit was on the market and taking applications. So this is a way that testing can help us better identify what exactly is going on at properties and identify more stealthy forms of discrimination. So I want to talk a bit about where our rights come from in the context of housing discrimination. So the Fair Housing Act is a national law that passed in 1968 that makes it illegal to discriminate in housing. So this law applies everywhere in the United States, not just the DC region, and it applies to all housing related transactions. So a lot of times when we talk about housing, we might immediately think about either renting somewhere or maybe buying somewhere. But this law applies to renting, it applies to home buying or selling. It also applies to lending, such as when you get a mortgage so that you can buy a home, or maybe you get a home loan as a homeowner in order to help pay for maintenance that needs to happen to your home. It also applies to insurance, such as renter's insurance or homeowner's insurance. The law applies to homeowners associations, condominium associations, and housing cooperatives. So this law is quite broad and applies to in many different housing contexts. So now what I want to talk about is who is protected under this law. We know what settings it applies to, but who actually is protected? So the first protected class, which is essentially an identity upon which it's illegal to discriminate someone, is race. And the next one is color. It is also illegal to discriminate based on national origin. So this applies to not only where you are from. Say, for instance, you might have been born in the United States, but your family is, let's say, from Guatemala, and a landlord doesn't want to rent to you because you're a Spanish speaker. This would still be considered national origin discrimination because the landlord is discriminating based on where your family is from, not just where you yourself may be from. The next protected class is familial status. This applies to families with children under the age of 18. So if you have any children in your household, then it is illegal to discriminate against you for having children. Disability is also protected. We actually did an extensive disability presentation on the rights of people with disabilities last month. And so hopefully there's a chance to view that again. I don't know, Adam, if you have details later, but we have talked about that, and there's a lot of additional protections for folks with disabilities in housing that we aren't going to go into today. But I just want to make you aware that their disability is protected, and there are some additional protections as well. Then there is religion is also protected, and then sex. And sex not only refers to like men and women, but it also refers to your gender identity and your sexual orientation. So this is not just what's on your birth certificate, but how you yourself identify and your sexual orientation. Okay. Next, in Washington, D.C., so all the identities we just went over, the 7 identities, these are all protected nationally. No matter where you live in the United States, it's illegal to discriminate against someone based on any of these identities. Now, in Washington, D.C., specifically, we protect based on several additional factors. So for instance, one is age. We see, for instance, like a lot of places advertise that they're great for young professionals and whatnot. But if, say, a property was trying to promote having like a young community and they were turning away older individuals from the property, that would be considered illegal under age discrimination. Marital status is also protected, whether you're single, married, widowed, separated. Sexual orientation is specifically protected. So folks who are gay, lesbian, bisexual, pansexual, they would be protected under this. Gender identity and expression is also protected. This is really important for trans individuals who may be experiencing additional barriers in housing due to stereotypes or just general transphobia. So it's illegal to discriminate based on someone's gender identity. Source of income is also protected. And this is essentially how you get your money to pay rent. So the most common type of source of income discrimination we see in DC is towards people with housing vouchers. And this is an example of a housing voucher is sometimes called Section 8. It's also called a housing choice voucher. So people with housing vouchers frequently experience discrimination because landlords will refuse to take their vouchers, and that is illegal in the city. It is also illegal to discriminate based on familial responsibilities. In DC, political affiliation is also protected. This one is pretty unique, but it is illegal to discriminate based on whether you're a Democrat, Republican. I've personally never seen a complaint based on this, but there's always, time for a first. Then there's personal appearance. So my colleague had a case once where an individual went into a housing provider and tried to apply. But from the moment he sat down, the housing provider just kept asking all these questions about whether he was in a gang or had committed crimes. And in this case, the individual was white, so it didn't seem like it was racial stereotyping. But he had a bunch of tattoos. And it seemed like the housing provider assumed that someone with a lot of tattoos must be in a gang and engaged in criminal activity. And so in this case, he filed a complaint on that basis of personal appearance. Matriculation is also protected. This is a fancy way of saying someone is a student, so it's illegal to discriminate against students. And then status as a survivor of domestic violence, sexual assault, or stalking is also protected. So for instance, if there is information on your application that might be considered reason for denial, you might be able to ask that that information not be considered if it's directly related to your experience as a survivor of domestic violence, sexual assault, or stalking. So say, for instance, you have an eviction on your history from when you fled an abusive relationship and you weren't able to give, the proper notice due to your safety, and your landlord took you to court for an eviction. You might be able to ask that the new place that you're applying not consider that eviction when they're looking at your application because it's directly related to domestic violence. In this case, because no housing provider can know whether someone is a survivor of of domestic violence, sexual assault, or stalking, you would need to disclose to the landlord that the reasons that certain information was appearing on your application when they reviewed your materials. So you would need to proactively ask for this protection. So that's something to take into consideration. And if you're not sure whether you might be protected, you can always contact us, and we might be able to also assist you with submitting that request for an exemption. Another example for a protection for survivors of domestic violence would be asking for a unit transfer, even if, say, the building generally didn't allow transfers or something like that. They should provide a transfer for someone who needs to move units for their safety, or possibly end their lease early. Place of residence or business refers to where you live or where your business is. It's illegal to discriminate on that basis. The Office of Attorney General in DC, I think, has filed some lawsuits about certain businesses refusing to go to certain parts of the city to provide services. And so that would be discrimination on the basis of place of residence or business. So those are all the protected classes. Before I continue, I just want to take a moment and see if anyone has any questions about what the identities are or what would be considered protected. I will point out if anyone asks questions. It doesn't seem like we have any questions at this time, so I'm just going to go ahead to the next part, which is prohibited activities. So we have to.
Susan, can I just remind everyone, we do have our community partners who will be answering further questions. So if a question pops in your head, just write it down, and you can save it for when Susan asks for it, or you can save it to the end, and our community partners will also assist in answering those questions. Thank you.
Thank you. Yeah, please feel free to add questions at any time, and Dr. Carter will make sure that one of us answers them at some point. So if you're like me, and if you hold your questions to the end and then completely forget what you want to ask, just know that you can put it in the chat now, and we'll make sure to get to it. Okay, the next section is on prohibited activities. So these are actions that it would be illegal for a landlord to do based on one of the protected identities we talked about. So the first one, I think, is the most obvious type of discrimination we think of, and this is a straight up refusal to rent or sell to someone. So for instance, we had a client who had been wanting to move into like a group house, where there were going to be multiple roommates. And she had been texting one of the roommates and the owner of the home. And during this text exchange, at some point, the owner wrote back he had meant to only text the tenant, but accidentally texted both of them and said, I don't want to rent to her. I think she's African. And in this case, we assisted her with filing a complaint on the basis of race and national origin, because his assumptions about her being African was directly tied to him not wanting to rent to a Black tenant. And this is actually now under litigation by the Office of Attorney General in Virginia. This landlord is being sued in court over his behavior. So that is a direct kind of refusal to sell or rent. Frequently, discrimination is not this blatant or obvious. She only knew the direct reason that she was being denied because the landlord accidentally texted her instead of just his tenant. So the next type of discrimination is discriminatory terms and conditions. So for instance, this could be not allowing children in certain areas of the complex, like saying they aren't allowed to use the pool, they're not allowed to use common spaces, be on the grass, that sort of thing, in ways that restrict families with children from enjoying the same amenities that adults without children could enjoy. Another example would be overly restrictive occupancy standards, which is how many people can live in a certain unit. And I'm going to talk a little bit more about that in detail later on, so I'm not going to get into that now. Minimum income requirements that are designed to exclude people with vouchers from being able to live in a property would be considered discriminatory terms and conditions. Or for instance, requiring everyone at a property to have a social security number and not accepting alternative forms of identification to verify an application or a tenant. So for instance, there was a housing complex in Northern Virginia that had a significant number of Spanish-speaking tenants, and the housing complex wanted to force them out. So even though they were already living there, they instituted a new rule that everyone in the household had to provide a social security number. And not all the residents had social security numbers, although some of them did have tax identification numbers or TIN numbers. And the housing complex refused to take those because they were trying to evict Spanish-speaking tenants. So in this case, it was found that the property was committing national origin discrimination against those tenants that they were trying to evict. Okay, and next, another type of discrimination is advertising a discriminatory preference. We don't frequently see this in Washington, D.C., but we, up until recently, would come across quite a number of ads that say no vouchers, this property isn't set up to accept the voucher program, things like that. This has luckily decreased in the last year or two, but you still can occasionally come across discriminatory ads. Misrepresenting availability is another type of discrimination. This is what we talked about earlier in the beginning with the example where we saw the Black and white tester go into the property and the agent told the Black tester that the unit wasn't available, but told the white tester it was. And this also is similar to the story I gave earlier with the voucher holder who, once she disclosed she had a voucher, then all of a sudden the unit was off the market. So this is an example about misrepresenting whether a unit is available. Blockbusting refers to generally a practice that was going on in the United States in the early 1900s to 1960s, and it's where we get the term white flight. So housing developers and real estate agents would go into white neighborhoods and say, hey, did you know people of color are moving in? Black folks are going to be moving onto your street soon. And these white residents, out of racism, would panic and would sell their homes to these developers or real estate agents for way under market value frequently. And realtors would do things like they would just pay Black folks to walk down the street, and that was enough to terrify these racist white residents. So they would sell these homes for under market value, and then realtors and housing developers would flip the homes and make a huge profit. We don't really see this much anymore because essentially like white flight into suburban neighborhoods has already happened. But there was a case with this recently in Georgetown where a developer was for committing blockbusting by posting a sign when a neighbor was trying to sell their home, and the developer posted the sign in the neighboring home saying that it was going to be for voucher holders and students, ostensibly trying to use negative stereotypes about both communities to possibly get a discount on the home price. And so there were allegations of blockbusting on that basis. Steering is the opposite. Blockbusting is pushing people out. Steering is pushing people towards a certain community. So we see steering frequently occur when home buyers are looking for homes. Real estate agents will frequently show home buyers in neighborhoods that are majority, whatever the home buyer's race is. Steering can also occur in like an apartment complex if an apartment tries to push all families with children towards a certain floor or towards certain buildings, or they might try to push everyone with disabilities towards the first floor under mistaken assumptions about what type of housing folks with disabilities prefer. That being said, it is not steering if someone says, you know, I want a first floor unit, I use a wheelchair, I don't want to live, you know, on any other floor. Great. Agent can tell them only about first floor units. That's not steering. It's just respecting what the person said. But if it's a building with an elevator where it doesn't matter what floor the person who uses a wheelchair lives on, then telling that person you have to live on the first floor is steering because you're pushing them a certain direction. And then it is also illegal to harass, threaten, intimidate, or coerce tenants on the basis of a protected identity. We have unfortunately seen a rise in harassment cases in housing in the pandemic, possibly because so many people are home more. But we've particularly seen race-based harassment towards Black tenants and Asian American tenants. Sexual harassment has unfortunately been a long problem in housing and is also very much illegal. And we, for instance, have a case right now where a person with a disability requested accommodations and the landlord didn't want to grant the accommodations. So they have been harassing the tenant in hopes that the tenant will essentially leave the home of their own, and so that the landlord doesn't have to evict them. And so they're just trying to pressure the tenant to leave by making it as miserable of an experience as possible. So all types of this harassment would be considered discrimination and is illegal in housing. Then the last couple, one is inaccessible design. This refers to units that were built after March of 1991. They must have a moderate level of accessible features in the building and unit so that wheelchair users especially can navigate those units. Then retaliation is also illegal. So if someone says that, you know, I think that this is housing discrimination, I'm going to file a complaint, things like that, the landlord cannot retaliate against you for you enforcing your fair housing rights. And then finally, any other conduct which makes housing unavailable could be considered discrimination. So those are all the prohibited activities that it would be illegal for a housing provider to do. So now I want to give an example. Say you look at a property and a landlord tells the parent with two children that, sorry, that's a typo, with two children that they do not rent to families with children under the age of 5 because young children are too noisy and would disturb the individuals in neighboring apartments. So we have a poll where we want to ask you a couple questions. So just give us a minute to get the poll launched. So the first question is, do you think that this is discrimination? Yes or no? Second question is, what is the protected class? And third is, what is the prohibited activity? So take a minute or two to look this over, and we appreciate your feedback.
Okay, we have it's still rolling in. We do have a question. Do you want to wait for the poll or you want me to ask it now?
Go, now is fine.
Okay. Someone wanted to know, when you mentioned about the retaliation, if, what can they do about it? Can they withhold rent if the landlord retaliates against them, pointing out discrimination?
So if you think that you are experiencing housing discrimination, whether it's retaliation or any of these other activities, you have the right to file a complaint. You can file that complaint with the Office of Human Rights or with HUD. I would not encourage anyone to withhold rent if they do not talk to an attorney. I think that I'm not an attorney. I'm really not familiar with landlord-tenant law, but I would recommend if you were ever considering withholding rent that you talk to an attorney before doing so. And there might be other people on this call later who can better answer the question about the possible consequences of withholding rent.
Yes, thank you, Susan. We do have the Office of Tenant Advocate, and we do have Neighborhood Legal Services Program. Save that question for the end. Great question. Thank you for asking.
So thank you everyone who filled out this poll. 100% of you were correct. This would be discrimination. And it would be discrimination on the basis of familial status, because they are saying that children would not be welcome in the building. And this would be a refusal to rent, right? They're saying, no, you can't live here because your children would be too noisy. So good job to everyone. You all did great. Okay. So next, I want to talk a bit about source of income discrimination. And the reason I want to talk about this is some of the greatest number of complaints we get in DC are specifically related to discrimination based on vouchers. So if you have a housing voucher, or if you know someone with a housing voucher, this should be particularly helpful and relevant. So what does source of income mean? Source of income refers to any legal source of income that you get to help pay your rent. This can be from federal and local programs, such as vouchers. It can be like local rent subsidies, such as rapid rehousing, housing choice vouchers, or Section 8. It can also be emergency rental assistance, like the state EC funding. It can be Social Security. It can be disability benefits, unemployment insurance, alimony, any sort of legal way that you get rent money is considered a source of income. So also things like veteran benefits would qualify. Unfortunately, there still is significant levels of source of income discrimination in DC, especially towards folks with vouchers. And one of the ways that we see discrimination especially is through what are called minimum income requirements. So many properties in DC will, for instance, say, in order to live here, you need to show that you make 3 times rent. And the purpose of that is to make sure that you can cover all your expenses with including whatever the rent amount is. However, when someone has a voucher, the voucher is covering the rent, so they don't need to verify whether that person has the extra income because it's a guaranteed payment. So minimum income requirements for voucher holders should only look at the portion of your rent that you are paying. So what this means is, say you are looking to rent somewhere and maybe the total rent is $2,000 a month, but you're only paying $200 a month and your voucher covers everything else. In that case, if the housing provider has a payments or a minimum income requirement saying, well, you have to pay 3 times, you have to show that you make 3 times rent. In this case, they should say, okay, your responsibility for the rent is $200. 200 times 3 is $600 a month. So your minimum income requirement is $600 a month. And if you can show that, then you should be qualified. Some voucher holders pay $0 a month towards their rent. Their voucher covers everything. In this case, your minimum income requirement is also $0. And so you should be approved on that. You should qualify for the minimum income requirement. Another common issue we see for voucher holders especially, but for a lot of renters, are credit screenings. And DC has said that housing providers can choose to waive credit screenings for voucher holders, but they're generally not required to. So in many cases, a housing provider could opt to waive a credit screening if you have a voucher, but they can choose to run a credit screening if they want. That being said, if you have a voucher and your portion of the rent is $0, it is likely illegal to run a credit screening on you because you're not responsible for your rent. So a credit screening really isn't relevant to whether you would be a good tenant. So in that case, that may be a sign of discrimination. So I want to give a couple examples of types of discrimination that you might see if you have a voucher. So in the first case, we have someone come in and say that he's looking for a 3-bedroom unit and ask whether any are available. And the agent says, yes, we have one next month. And he says, great, do you accept rapid rehousing vouchers? And the agent says, we had a bad experience with a voucher holder a couple years ago. Since then, we haven't accepted any voucher holders. So this, we have a quick poll again for your perspectives. The first question is this discrimination? Second question is, what is the protected class? And third question is, what is the prohibited activity? If you want, we can wrap up the poll now. Great. So great job, everyone. This would be considered discrimination. The protected class is source of income because it's based on the person having rapid rehousing, which is a short-term voucher subsidy. And this is a refusal to rent for the individual. And the next example, a woman asks how minimum income requirements apply to housing voucher holders. And the agent says all applicants must make at least 3 times the monthly rent. She says her voucher covers most of her rent, though. I can prove that I make 3 times my portion of the rent. And the agent says, sorry, all applicants must show they make 3 times rent. We will count your voucher towards your income. However, your voucher and any other income must be at least 3 times total rent for you to qualify. She says, I think your policy might be discriminating against housing voucher applicants. And she says, well, we're treating everyone equally, so it's not discrimination. So if you want to launch the next poll. And the question is this discrimination? What is the protected class? And what is the prohibited activity? Great job, everyone. So yes, this would likely be discrimination based on source of income. And this would be considered different terms and conditions because essentially voucher holders are being asked to prove more income proportionately than anyone else is. So this would be a different term and condition. But as many of you indicated, it would ultimately likely result in her inability to rent the unit based on how they're applying their minimum income requirements. Okay, last example. A woman says that she is looking for a 1-bedroom unit for her and her son and asks if any are available next month. Agent says, yes, we do. And she says, great, do you accept housing choice vouchers? And the agent says, yes, but you must have a full-time job. Oops. So we have one last poll. And the question is this discrimination? What is the protected class? The prohibited activity. Great, everyone's doing so well. I appreciate all your participation. So this would be considered discrimination. Again, it's based on source of income because the individual has a voucher. And in this case, it would also be different terms and conditions because they're only allowing certain voucher holders to live in the property, specifically only voucher holders who have a full-time job. So thank you all for participating. And that brings us to the end of our section on source of income discrimination. I do just want to let you know, if you or anyone you know has a housing voucher, we did create this publication a couple years ago about your rights. It's available in English and Spanish and answers some of the most common questions we get about voucher discrimination in DC. Okay, so the next thing I want to talk about are criminal record screenings. So several years ago, the Equal Rights Center released a report called Unlocking Discrimination. And in it, we conducted tests at many properties in the DC area related to their criminal record screening policies. And in some of the cases, we saw that regardless of, in this case, we had Black women and white women posed as testers, and both disclosed that they had a criminal conviction. And in some cases, we saw that just automatically, Black women were being treated worse than white women when they disclosed the same information. So in this is an example of one of the tests we did. So in this test, both the Black woman and the white woman disclosed that they had a felony conviction on their record from 15 years ago. And the agent tells the Black woman, yeah, they won't approve you. Whereas the agent tells the white woman who discloses a criminal record, a third party makes that decision. It depends on the type of crime and how long ago it was, which sounds like a completely different policy than what the Black woman was told. So in this case, we see that this criminal record screening is actually just serving as an excuse to discriminate against Black folks, right? Because Black people are not being treated the same as white people with the same criminal conviction. So this would be considered straight up race-based discrimination at this property. That being said, we also sometimes see, and what's important to keep in mind is that even when policies are applied the same to everyone, the results can have very different impacts on different communities. And we know that people of color are incarcerated at much higher rates than white people. They are much more likely to have a criminal record. And that is not due to anything that people of color have done. It's just due to the racist history of our criminal legal system. And we know that people of color are targeted in ways that white people are not for enforcement of laws. And so that results in a disproportionate number of people with criminal records being people of color. And about 5 years ago, HUD, with the US Department of Housing and Urban Development, released guidance on how housing providers should apply criminal record screenings in a way that is not discriminatory. And so there were several things to keep in mind. First is that housing providers should never be considering arrest records. So if you get denied or you see that the housing provider was looking at your arrest record, that is a sign of possible discrimination. Second, there were buildings that would just outright say, we don't take anyone with a criminal record or we don't take anyone with a felony. And they were applying what are called felony bans or conviction bans. So they're just banning anyone from the building that has a record. Those are also illegal because they're not effective screening tools. So for instance, a couple of years ago, we came across a property that had an online application. And one of the questions that was asked was, have you or any other applicant or occupant ever been convicted of a felony? And if you put yes, this pop-up appeared and says, we are unable to reserve an apartment for you. And we actually sued this housing provider alleging that this was race-based discrimination because they were applying a complete felony ban to the property. So what housing providers should do is they should make an individualized assessment of a person's criminal record. So they should be individually considering everyone who applies and looking at that person's record and that person's application. So there's certain information that at minimum they should consider. First is they should look at what crime was committed. Second, they should look at when the crime occurred. Third, they should look at how long it's been since the crime occurred. So we have had multiple folks contact us when they got denied based on a criminal screening because they're getting denied from like a single felony from the like 1980s or 1990s, right? So this happened decades ago and is not a good indicator of whether they would make a good tenant. They should also consider your age when you committed the crime. Finally, they should also look at any changes in your situation since the crime occurred. So you have the right to submit additional information about maybe your motivations or further details about the situation that occurred. Also things that have changed in your life since then, your life now. For instance, we were working with someone who had like a bounce check or something related to like small theft on their record from years back. And one of the major things in their life that had changed is they now had a voucher, and that now meant they were stable and could afford, the basic things they needed. And that was a major game changer for them. And so one of the things they included in the letter was, while they, didn't condone their actions, their life had significantly changed since then, and their voucher had made a real difference in their ability to take care of themselves and their family. Okay, now that being said, there are additional protections in DC based on your criminal record. So this does not apply nationally. What we were talking about just now applies to everywhere in the United States. However, Washington, DC passed the Fair Criminal Record Screening for Housing Act of 2016. And so there are additional protections underneath this law. And there are actually some other panelists tonight here that know way more about this law than I do, but I did want to bring it to everyone's attention. In Washington, DC, a housing provider must provide you a written list of application requirements before you apply. So a housing provider needs to tell you in writing what they are looking for from you before you submit your application. And this is really helpful because if you have in writing what the housing provider is looking for, and then they deny you, and the reason they deny you for isn't in the criteria they told you they were looking for, that's a sign of possible discrimination. Another thing to keep in mind is that in DC, landlords can only look back 7 years at convictions or consider pending charges. So anything older than 7 years ago on your record cannot be considered by a housing provider if you're applying to rent places in Washington, D.C. So an important thing to think about is if anything is on your record, if it's older than 7 years ago, your landlord shouldn't be looking at it at all. Now, if you are denied after they run a criminal record screening, the housing provider must provide a written notice that tells you specifically why you were denied. This has to be in writing, and it has to give the reasons your application was rejected. So what happens, the process is supposed to be that the housing provider gives you the written criteria. You then submit your application. The housing provider is then supposed to look at everything except for your criminal record and give you what's called a conditional offer of tenancy. And this means that they say that your application passed pending a background check. And so they need to now run that. Or they will give you a denial saying that you were denied for another reason and they never ran a background check on you because you didn't get to that point. But if you get a conditional offer of tenancy saying that you're conditionally approved, they will run a background check and then tell you if you get denied in writing based on your criminal record. If you do get denied by a housing provider in Washington, D.C., you can ask for free copies of all documents they use during the review of your application. And they have to give you those copies. We've had landlords try to get around this by saying, oh, you can get a free copy by calling this like credit agency or calling this background check agency, but that's not sufficient. They actually need to give you the copies that they looked at. And this allows you to fact check the information they reviewed to see if that matches with the reasons they gave you for denial. Okay, so what does this look like in practice? One, we recommend that when you want to apply somewhere, you ask for the application requirements and get them in writing from the landlord. Then, only once you have them, you submit an application if you think that you will qualify. They check everything except your criminal record, and they conditionally approve you or deny you. If the application then is denied, they'll let you know why. If it's approved, they'll run a background check. And they'll either give you a final approval or denial. If they deny you, they need to tell you in writing why you're denied. So to go over a scenario, let's say that a person with a felony conviction is denied housing because the building says they have a total felony ban. They don't allow anyone with felonies to live there. And we have a poll regarding this.
We actually have two questions. One question was directly related to, you said the landlord must provide the denial documents that they use. This person wants to know, what is the time frame? Like, must the landlord show him the documents they use to review him as an applicant?
Yeah, so you have 20 days from your denial to request them. We recommend that you make this request in writing so that there is proof of it. Then they have 10 days to turn over those documents to you.
Okay, that's a good question. Thanks for asking. The other question was, someone asked if I renewed my lease and was arrested in between, and then the landlord decided not to renew it, could that be discrimination? So I guess the time frame between when they were on the lease to now they hit the renewal and the landlord found out that they were arrested.
So I don't know if there's any landlord tenant protections related to lease renewals. So this might be a good question to ask the panel as well. But if a landlord ran a criminal record screening on you and you have a pending charge, meaning that it has not been decided whether you're found guilty or not, right? You haven't been convicted of anything or had it dismissed. Generally speaking, housing providers can consider pending charges. However, say they run a criminal record screening and you have something on your arrest record that's new, but it's already been dismissed in court, they can't consider it because it was never a conviction. So if it's just an arrest and it's already been dismissed, it shouldn't ever be looked at.
Thank you.
For those questions, those are great.
I'll go ahead and kick off the next poll.
So the questions are, is this discrimination? Can a landlord deny anyone with a conviction? And what information should the landlord have considered?
And if you have any questions, even if you feel uncomfortable or you feel like, you can go ahead and ask, just continue to send me in private chat. And no question is a silly question. We welcome all questions. Okay, so the poll is still open. We'll go ahead and stop it and share the results.
Okay, so for those who said it was discrimination, you are correct. It is illegal for a landlord to just outright ban anyone with a conviction from living at the property. So this would be a sign of likely discrimination. For the sake of time, I'm going to skip the next example. And the last thing I want to let people know is that the Office of Human Rights in Washington, D.C., which is the agency that investigates complaints regarding this law, the Fair Criminal Record Screening and Housing Act, has a fact sheet for people looking for housing. So if you have questions during your housing search related to criminal record screenings or the process that a landlord should be using when reviewing your application, I would recommend checking it out. Unfortunately, they have not released it in Spanish. Okay. So the last topic I want to cover before discussing what options are available to folks if you think that you might have experienced discrimination is occupancy standards. And this is a way to occupancy standards just refer to the maximum number of people that can live in a unit together. So for instance, it might be that there is a maximum of 3 people allowed in a unit. That's the occupancy standard, total number of people that can live in a unit. Usually, the standard for determining how many people can live in a unit is that there can be 2 people per bedroom plus 1 additional person total. So what this means is that in a 1-bedroom, the maximum number of people that should be able to live there is usually 3. In a 2-bedroom, the maximum number of people that should be allowed to live in a 2-bedroom is 5. The maximum number of people who can live in a 3-bedroom unit is 7. Maximum number of people that can live in a 4-bedroom unit is 9. And maximum number of people that can live in a 5-bedroom unit is 11 people. And the reason I want to go over this is what we sometimes see landlords do is they'll say, oh, you're looking for a 3-bedroom. What's your family size? Oh, you have 6 people. That is way too many people. I don't want that number of people in my home. my 3-bedroom only allows three people total in it. And so they're trying to avoid renting to families that way. So landlords cannot further limit the number of people allowed in a unit, and it would likely be familial status discrimination. So if you, for instance, are a family of 7, you should be able to rent a 3-bedroom. If a landlord is saying, you know, that's too many people, that's going to be too much wear and tear on the unit, I'm not comfortable with that, that may actually be a sign of discrimination. So as an example, let's say a family of 5 wants to live in a 3-bedroom home. The landlord says they won't rent to them because their family is too big. They'll only rent to a maximum of 3 people. So we have a poll about this. See if it. Major props to Dr. Carter, who's been handling all the polls this session. I am not this good at Zoom, so I appreciate all the technical assistance. Oh, nope, sorry, I skipped this one. I did not tell you that. My apologies. There we go. Thank you. So the question is this discrimination? And if so, what is the protected class? And we'll just keep this open for a short bit so that we can make sure to get to the end with the Q&A period and the other panelists. Okay, great. Everyone was correct. This would be considered discrimination based on familial status. So the last couple things I want to talk about are what to do if you may have experienced housing discrimination. So if you think that you've experienced discrimination, you have a right to file a housing discrimination complaint. You can file that complaint with the Equal Rights Center, which is where I work, with HUD, or with the DC Office of Human Rights. So I want to quickly go over the type of services that the Equal Rights Center offers. So the first thing that we can do is we can do direct advocacy with the housing provider to address possible discrimination. So say, for instance, someone contacts us, they were denied due to a felony on their record. We can help them appeal that decision with the landlord so that they can actually access housing. So that way we can rectify the issue in that moment. Another thing we can do is we can assist people with disabilities with submitting reasonable accommodation or reasonable modification requests to housing providers. For instance, asking if someone needs a unit transfer due to a disability, if someone needs an emotional support animal, things like that. Those are things that we can assist with, and which we went over in a lot more detail in the other presentation we did last month. So I hope folks were able to attend that one. We can also assist people with filing housing discrimination complaints with the DC Office of Human Rights or with HUD, and serving as that person's representative or advocate throughout the process. And one of the questions I got was about the effectiveness of these processes, because while discrimination is obviously terrible, it can be really exhausting for people to report it and go through the process. And so I really understand that, and it just adds one more thing if you're already looking for housing to then have to go report it. And so we actually will walk people through the process and help them throughout, so that takes a lot of the work off of them, and so they know what to expect the entire time. And so we have found that walking through the process with people results in a lot more satisfying outcomes, because people feel better able to engage in that process since they have a better understanding of what's going on and what they can expect. Because otherwise it can be a very confusing and long process. So I definitely would recommend that, I would definitely encourage, if folks have questions more specifically about that process, we are always happy to chat with people directly about what it entails and whether it's a good option based on their circumstances. We also do civil rights testing, which I've talked about quite a bit. And then we do accessibility site surveys. So if you live in a building that was built after 1991 that you think might not be meeting the accessibility requirements, so it's not very accessible for folks with disabilities, we can come to the building and survey it to see whether it's likely in compliance with the law. Finally, some other things to keep in mind if you experience discrimination. It is always really good to document what is happening. The date and time conversations occur, who you spoke to, what their job title is, what they told you, a summary of what happened, and make sure if you get anything, if you submit anything in writing, always have a copy of it. So make sure to make a copy for yourself as well. Finally, if you want to file a complaint with us, you can call our direct number or you can email us. And then I've also listed our intake coordinator's direct phone and email as well, so you can reach out to her. We will be circulating the slides after this presentation, so you will have access to that information as well. So that wraps this up. Thank you all for listening to this presentation. And I know we have a couple other speakers now, so do not leave yet because we have a Q&A period coming. Thank you.
Yes, thank you so much, Susie. That was such an informative presentation. Continue to send me the questions. If we can just take another minute or so just to answer these survey questions, and then we'll just get the community partners ready to answer whatever questions you have. And also just to give you information on what the organization does and how they can assist you on any housing matters. So just give me 1 second, and I'm just going to go ahead and just 3 questions, if you can just answer it, just so Susie does a great job every time, and she's always trying to inform the community. But if there's anything you think we can do better, we love to hear it. Thank you. We'll just give it a couple more minutes. Okay, so we can go ahead and get started with the Q&A section. We're going to start with Susan Jacob from the Housing Counseling Association. I'm just going to go ahead and share my screen.
Okay, hi everyone. My name is Susan Jacob. I am the program director at Housing Counseling Services over the ERAP program, and right now State EC as well. I'm just going to very briefly talk about some eviction updates and status on what's going on with them, since things are changing sort of quickly and a lot of things have happened recently. The first thing is, and I just want to preface this by saying I'm not an attorney. There are other attorneys on the call to talk about the substance of the legislation if you have questions. But what I can tell you is that there has been new eviction legislation passed this month. It just happened maybe about a week and a half ago. And essentially, this only applies to people who had case filings on non-payment of rent or other non-payment of rent prior to March of 2020. Basically prior to the pandemic starting and the public health emergency starting. And so what has happened is that if somebody has a scheduled eviction right now, and evictions did start on September 13th, if someone does have a scheduled eviction, the landlord actually has to determine if there is a pending state DC or ERAP application The applications do not have to be approved, but there has to be some sort of documentation or evidence that the person is, the tenant actually has a pending application that can be presented in court, and the landlord can then, will then be required to cancel that scheduled eviction, and it has to be, it can be rescheduled for at least 3 weeks out. So 3 weeks out, but then the marshals, US Marshals are the ones that set the schedule. So there could be actually some additional time. The way that it's been working right now is, ooh, can I get my slide? No, it's okay.
Okay.
The way that it's working right now is that we have attorneys contacting us or contacting the Department of Human Services to determine if there is an active state EC or ERAP application. And if that is the case, a lot of tenant attorneys are going into court right now to file a motion to quash or stay the writ by showing that someone has a pending application. So if you fall into that category, or you know someone who falls into that category of having a scheduled eviction because they were behind prior to March of 2020, then this legislation should apply to them. My number one advice would be to make sure that you are connected to an attorney. So there are new filings for people who, so the new filings are for anyone that basically accrued some sort of rental arrearage during the pandemic. During the pandemic, there was a moratorium on filings, and that ended on October 12th. So starting on October 12th, landlords could go to court and file new court filings for people that were delinquent on their rent. The filing started on October 12th, and the evictions in those cases cannot begin until after January 1st. I know that there are lots of community leaders, people in the legal service providers, and a lot of different organizations that are working right now to present ideas and what the challenges would be for this to DC Council. But for right now, the new filings began on October 12th, and evictions for those new filings can begin to be scheduled starting after the first of the year. How can tenants obtain, with writs, obtain assistance now? So Housing Counseling Services is actually working with DHS and the State EC program to assist anyone who has a scheduled eviction, a writ, or a judgment to obtain assistance with applying for ERAP and the State EC program. So let me just jump to the State EC updates. That program is actually going to be closing the portal on October 27th. And the reason for that is because the funding for that program is winding down. Instead of taking in more applications without having the backing of funding, they are closing it on October 27th. Up until that point, anyone is still allowed to apply for the State EC program. If somebody has a writ, a judgment, or a scheduled eviction, and they are coming to Housing Counseling Services, we will automatically have you apply for ERAP and for State EC if you are eligible for those programs. So I have put on this slide our contact information for people that fall into those categories. And even if it's after October 27th, you can still contact us if you have a scheduled eviction, writ, or judgment, or you know anyone that does, because we will still try to assist you at least with the ERAP program, which did begin, well, the fiscal year started October 1st. And so we are able to assist people in those situations with ERAP. ERAP for the general public at this point, it's still not open. There is an ERAP portal that DHS has been working on to do many, to update the access to the system. That's not open yet, but DHS is going to be announcing that very soon. And once that does come into play, people should be able to apply for ERAP online, as well as there should be a phone number where people can also call if they need assistance if technology is a challenge. So that's my very brief update on evictions. I'm happy to take questions once the other panelists have also presented or answer questions in the chat if that is what you would like to do. Thank you.
Thank you, Susan. We're going to go ahead and switch slides to Chris. He's going to be speaking on behalf of the Office of the Tenant Advocate.
Okay, hi, good evening. Can somebody hear me?
Yes.
Sweet. All right, so real quick, so the Office of the Tenant Advocate is a DC government agency. We're a small independent DC government agency. And our mandate by law is to provide technical advice and other legal services to tenants regarding disputes with landlords, right? So you didn't get your security deposit back, you're looking at your lease and some clauses seem funny, like all of that in between. We do this, and then also to educate and inform the tenant community about the rights and rental housing matters. That's what I do. And then to advocate for the rights and interests of district tenants in the legislative, regulatory, and judicial context. And finally, to provide financial assistance to displaced tenants for certain emergency housing and tenant relocation expenses. So just one example, the quickest one is a fire, right? So if there's a fire on the 4th floor of a building, that 4th floor, people can't go back in there, and maybe the 3rd and 2nd floor because of the water. So the Office of the Tenant Advocate has a pretty unique program where we provide emergency housing in those situations. So that is our mission statement, right? And the way that we accomplish this is through 4 branches in our office. The first one being the Legal Services branch, which is the personnel there are case management specialists and attorney advisors. So they deal with issues, again, ranging from security deposits to illegal rent increases to eviction prevention, right? Our policy branch drafts legislation, provides testimony to the council and other rulemaking agencies and administrative bodies in order to have, laws that are fair to tenants, right? And that take tenants' rights into consideration. The Education and Outreach branch, which is myself and one other individual, we have the Educational Institute, we have trainings, tutorials, we help tenant associations form themselves, and et cetera. And then we have the Emergency Housing branch, which we respond to displacements throughout the city. So that's what the Office of the Tenant Advocate does. And if, from what I'm saying, if you take one thing away from it, is our tenant hotline phone number, which is, if you have a phone with you right now, just break it out and put 202-719-6560. Our mandate is to assist every tenant in the District of Columbia. There's 300,000 plus. So that's our job. If you need help, give us a call, 202-719-6560. Thank you.
Thank you, Chris. So we're going to move on to Neighborhood Legal Services Program.
Hi, everyone. My name is Sam Stringer, and I'm a project coordinator at Neighborhood Legal Services Program, or NLSP. I'll also add the quick disclaimer that I am not an attorney, but I am going to cover our services very quickly for you all. So NLSP is a nonprofit law firm. We provide free legal information, advice, and representation to low-income residents of DC. We have many different service areas, including family law, consumer law, employment law, student loans, wills, public benefits, and most relevant to this webinar is housing. So our housing team works on a variety of issues, mostly eviction, voucher termination, housing discrimination, and building-wide issues. So if you feel that you've been, from Susie's presentation, if you're concerned that you've experienced discrimination, or as Susan mentioned, are facing an eviction in this new coming wave post-eviction moratorium, please reach out to our team. Our information is on the next slide. We are ready to assist people who are facing eviction, as well as provide advice or representation to those who have experienced discrimination for voucher, for source of income discrimination or criminal history. Our intake information is on the screen. You can give our intake workers a call at 202-832-6577. And our intake hours are Monday, Wednesday, and Friday, 10 a.m. to 3 p.m. Or you can call and leave a message and they'll get back to you. Thanks, everyone.
Thank you, Samantha. And we have one more. I just have to stop sharing my screen for 1 second. just need to. Thank you for your patience. I just have to get me Casa's slide.
I have it up on my computer. I can share
Oh.
my.
Okay, thank you.
Yeah, no problem.
Okay, let me just give you access.
Can you all see that? Okay. Cool. So,
Yes, I can see it. Can
okay,
everyone
awesome.
else?
I hope so. Okay, my name is Robert and I'm with Casa. We are a affordable housing developer slash consultant for limited equity co-ops and tenant associations that want to become limited equity co-ops slash a whole bunch of other things in that realm and field, but those are sort of our two primary projects. So we work with basically groups that have exercised their tenant rights, either to form cooperatives and own and operate their buildings, or to assign those rights to a nonprofit developer like us or somebody else who will own and operate the building as permanently affordable housing with them or for them. The primary thing I wanted to highlight here is, in addition to that work, we do a number of trainings, mostly focused on cooperatives, but with a lot of broad appeal. We actually did one maybe 2 weeks ago, if not more recently than that, with a whole bunch of folks on this call, also focused on fair housing, but more focused on the marketing aspect of that. So if you're interested in that information, please feel free to reach out to us. We're happy to share slides and information from that as well. But we have a training coming up on November 18th at 6 p.m. And this is about asset management, which basically means now that a cooperative or a tenant association or even an individual owns a home or a property and wants to run it in a way that is sustainable and also equitable and just for the people that live there. What does that mean? What are the things that you have to think about? You know, what are the day-to-day operations that you need to be concerned about? What are the medium and long-term projects you need to be working on? How do you integrate asset managers, property managers, board members, all the different people that work in your building and work on your cooperative boards? What does financial oversight look like? You know, compliance and reporting and all of those things that you need to do to work with the city government on that. So if you're interested in that, if any piece of that sounds interesting to you, we have a link here. You can also reach out to me directly. I'll put my email in the chat and would love to hear from y'all.
Great, thank you, Robert. I am stepping in for Dana as we had some technical issues at the end over there, but I wanted to thank everybody. I think we have maybe a moment for one question from folks. Let me see. We have one from the chat saying, my case manager has told landlords that they cannot tell me how much assistance I will receive until after I'm approved for an apartment. What can the landlord consider for an income requirement or credit check if my subsidy doesn't say what my right portion is?
A great question. Usually these programs require that you say that you can't pay any more than 30 or 40% of your income towards rent. So if the housing provider has any questions, and I haven't actually seen this come up, but you could reference the program requirements. But generally speaking, if you're running into issues with minimum income requirements as a voucher holder, I would recommend that you call the Equal Rights Center, Neighborhood Legal Services Program, or another organization that helps with these sorts of issues.
All right, I guess maybe I'll sneak in another quick one. Can landlords that don't advertise be guilty of discrimination under fair housing?
Generally speaking, yes.
All right, so get in touch with one of the three of these people if you see this happening. So I want to thank everybody for coming. We are right at our time. So we are going to close out. I want to thank my colleagues for attending and hope that the rest of the participants will continue to join our presentations. We have another presentation, co-op presentation coming up on November 16th that will go over fair housing compliance. So if you are in a co-op, it will help you stay within the law. So we look forward to speaking to you then. And until then, have a nice night.